Welcome to Law Help Australia, where we keep you safe and informed with tips and updates. My name is Dinesh Weerakkody. Have you ever been to a criminal trial, either in the Supreme Court or in the Magistrates Court? Do you want to know the questioning style, the court etiquette? Let's find out now. But before we do that, let me introduce you to the panel today. Harlis, can you tell us a little bit about yourself, please?
Sure. My name is Harlis Kirimof. I have two roles. One is as a barrister, which is a kind of lawyer. It's the kind of lawyer that really deals with disputes and appears in court. And my other role is as a lecturer, so I lecture at Deakin University.
That's a good university, by the way.
It is.
And Chen?
Yes, hi. My name is Chen Yang. I'm a principal of Vale Criminal Law. We specialised in criminal law and traffic law. I've been practicing for about 4 years and I'm a solicitor.
And Emily?
Thanks, Dinesh. I'm a lawyer at DLegal. We're practicing mainly in criminal, family, property and conveyancing matters, and traffic law as well.
All right, okay. Let's start. So, let's start from the beginning. What is a criminal trial?
A criminal trial is the main court hearing in which the jury hears evidence and decides whether someone is guilty or not. There are two places really in Victoria where criminal trials are heard. One is the county court, the other is the Supreme Court. There are contests in the Magistrates Court where there's no jury, so technically it's not a trial. They're called contests, so trials are in the county and Supreme Court.
All right. So what is the purpose of a trial?
Dinesh, the purpose of the trial is to present evidence. So you've got the prosecution who present their side of the evidence, and you've got the defence who then responds to that and provides their side of the evidence, and then ultimately, once the evidence have all been provided, the jury then determines whether or not a party is guilty or not guilty.
Let's talk about the Magistrates Court for a moment. If the magistrate decides that there's not much evidence, is that the end of the trial?
Do you mean the magistrate, Dinesh, or
the magistrates, yes.
Well, not always. The Office of Public Prosecutions will review all cases. Sometimes the Director of Public Prosecutions will then decide to still take that accused to trial anyway.
Who usually decides a criminal prosecution, or who does the prosecution?
In the Magistrates Court it's the police, so there's a special group of police officers who are police prosecutors, and to become police prosecutors they receive special training. They're not usually out on the streets, they're in court. But in the high courts, in the county court and Supreme Court for more serious offences, it's the Office of Public Prosecutions and the barristers that they retain.
So they might be for a barrister, as you said, retain a barrister.
Yes, absolutely.
Yeah. Yeah. So what is the role of the police prosecutors?
It's to make our life difficult, isn't it, Hans?
Yes,
basically. No, but what they do is they lay the charges, and they will get the evidence from the informant, and they'll determine whether to proceed with the case or to negotiate with us sometimes, or if a negotiation cannot be reached, then to run the case as a contest.
By negotiations, do you mean negotiations on whether certain charges proceed and others not?
Yeah, there's two kinds of negotiations. One is proceeding on the main charge, and then the alternative lesser charges gets negotiated out, or alternatively, the main charge gets negotiated out and you plead guilty, for example, to a lesser charge. That's their role.
Who initiate criminal cases, let's say in the trial division in the Supreme Court?
Well, Dinesh, the Supreme Court is a Victorian court, so any matters brought to trial in the Supreme Court are done by the Director of Public Prosecutions on behalf of the people of Victoria. And in all criminal cases, as we've already heard, it's heard before a judge and a jury.
So what does the jury do?
The jury has all the power in the proceeding in the end. They are the ones who finally decide whether someone's guilty or innocent. And they do that by, first of all, listening to all the evidence, which can range anything from a day or 2 days. It can go for 6 months, depending on how long the trial goes for. They then listen to the lawyers make their argument. They listen to the judge's directions about how they're to conduct their job. And then finally they go into a room and they discuss it and they come out with a verdict.
So let's go inside, let's say, the Supreme Court. Who's there?
Well, first of all, one of the most important members is the actual judge, him or herself. And the judge's role is essentially like an impartial referee. In Australia, we've got the adversarial system. So what they do is they will rule on evidence presented by both sides. They will also conduct procedural hearings. They also rule on things like voir dires and things like that, where the jury is actually outside the courtroom when these hearings are conducted.
So that's the judge.
Yeah.
We also have, associates, tip staff, court reporters and barristers. They're instructing solicitors, the jury, witnesses. There's all sorts of parties involved, and even the public, depending on whether the matter's open to them, and can go into the courtroom and see the proceedings.
One further thing I should add is that the jury is the party who decides whether someone is guilty or not guilty. But once that decision has been conducted, then it's up to the judge to sentence the individual if he or she is found guilty.
Right.
So that's a very important role of the judge as well.
Sentencing is it's a very loose process, and the High Court has said over and over again that a trial judge has to sentence by using a process called what's called instinctive synthesis.
Right.
In other words, they
You'll have to explain that.
It's essentially using their gut feeling to decide what the right outcome is.
Right.
And when we say sentence, it's really what people commonly call punishment, but really it's the final order of the court. And so what some people might think that the sentence is arrived at by taking a kind of average figure for a particular crime, say 5 years. But because there are particularly bad circumstances, you might add it a year. Or there are mitigating circumstances, you might take away a year. But that's simply not allowed. The High Court has said you're not allowed to do that. There's no two-step process. You just have to throw the dart once and get the right result.